So it is the Attorney General who is seized with responsibility to defend the Constitution of the Republic of Ghana in a matter of interpretation of the Constitution. So we have no problem with that. Now, the problem is simply that the Attorney General had raised issue of the constitutionality or otherwise of the existence of the Office of the Special Prosecutor. The members of Parliament on the majority side, led by the majority leader and the majority chief whip, had indicated their intention to file a private member's bill to scrap the office of the special prosecutor. 2 days after they were prevailed upon to withdraw their suit or their intention to file a private member's bill to scrap the office of the special prosecutor, Dumpty filed a suit at the Supreme Court seeking an interpretation to Article 88 and particularly Article 88 3 and 4 as, as against Section 4 2 of the Special Prosecutors Act, Act 959. So the chronology of events seems to lend credence to a concerted effort by persons who are aligned to the Attorney General's office to, if you want, challenge the existence of the Special Prosecutor's office. This is the worry. This is just the worry I have.
How do we balance out the scale? Because at this point, and I recall that thing happened under the Akufo-Addo regime once, where the AG was basically upholding the opinion of the, I don't know whether you call them the plaintiff in the matter, and so there was a feeling that the other person involved was not being well defended. How should this be balanced out? Because it seems the special prosecutor has attempted to be joined to the matter and failed. What happens?
Yeah, so that is the Richard Sky case that you are referring to, where Richard Sky had filed a suit in the Supreme Court challenging the power of Parliament to pass the family values and what bill, morality bill or ethics bill. I mean, otherwise known as the LGBTQ bill. And the Attorney General Godfrey Dami had essentially agreed with the petitioner in the case, that is the Richard Sky, that the bill was unconstitutional, or Parliament had acted unconstitutionally. Parliament was allowed in that instance to hire a lawyer to defend it because the Attorney General had basically agreed with the petitioner that what Parliament had done was unconstitutional. So this is a case where, even though the Attorney General is the mandated institution to defend the Constitution, the Supreme Court, in that instance felt that Parliament interest was not adequately represented, and that Parliament could retain the authority in that case to defend its interests. I think that should animate what is happening now, because even though the suit is not, as I repeat, the suit is not against the special prosecutor. The suit is against the creation of the office of the special prosecutor. The suit is arguing in terms of the existence of that office as against the constitutional provision, Article 88 3 and 4, that vest exclusive prosecutorial authority in the Attorney General, and whether or not Parliament can statutorily delegate a power to an institution to prosecute in the name of the Attorney General. That's basically what the suit is trying to achieve. And if the court comes to the conclusion that the Parliament cannot do what it did, then the law that particularly section 4.2 of the law will be struck down as being unconstitutional.
Whoa. Okay.
And that section 4.2 gives the Office of the Special Prosecutor operational independence. When you listen 4.2 and 4.1 and 4.2 together. So that is basically what the suit is trying to do.
So once you take away that operational independence, what happens?
So it means that the Attorney General can only operate under the control and direction of the Attorney General. The Special Prosecutor can only operate under the direction and control of the Attorney General.
Wow. Would that not essentially be a reversal of the original intention of the Office of Special Prosecutor of setting up that office?
That's what many people are thinking, including me, that we'll go back to the status quo ante, and then the reason d'etre for the establishment of that office will cease to exist.
But Alhaji, does it also not provide us opportunity to correct that constitutional, I don't know whether to call it wrong, that even you accept that the steps that needed to have been taken were not properly taken to give it real independence?
You see, so you are right that when the bill was introduced in Parliament, all of us, I as ranking member, in my contribution to the second reading, that is the policy, the debate on the policy on the bill, we had raised issues about the attempt to break the monopoly of prosecutorial power vested in the Attorney General. And we had said that that attempt might require a constitutional amendment. And you can't use a statute to break the exclusive prosecutorial power vested in the Attorney General. We had made that argument. But during the stakeholder engagement on the bill, civil society organizations, the Attorney General's office, the NCCE, and the American Embassy, and many other publicly spirited persons who were part of the bill, and particularly Professor H. Prempe, Kojo Asante, Jima Bwedi, who sat with us throughout the consideration of the provisions of the bill, gave some conceptual clarity to what we were trying to achieve, and negotiated the difficult contours of Article 88.3 and 4 with us by providing a way out and still making the Attorney General the authority with the exclusive prosecutorial power, albeit with the power to delegate some of the powers to other bodies to prosecute on his behalf. So when you look at the long title of the bill, the special prosecutor prosecutes corruption and corruption-related offenses under the authority of the Attorney General. It's stated there clearly. So the long title of the bill, you will find that can only be done under the authority of the Attorney General. Now, but you are looking to cure a mischief where you want to give the special prosecutor some operational independence, structural independence, and financial independence. You want that institution to be independent of the Attorney General, so that you don't have that Attorney General refuse to give a fiat for the prosecution of some corruption cases or corruption-related cases. Now, I would say that Section 4.2 of the bill was particularly affected by the discussions of the present Attorney General, Honorable Dominic Ayini, and amendments suggested by Dominic Ayini to try to reconcile the apparent inconsistency in what we were doing with the Constitution. So, in fact, the Article 4.2 as it exists was largely crafted by amendments proposed by Honorable Dominic Ayini. Whether that amendment secured what was intended to achieve, that the structure, the form, and responsiveness of the office, we have always known that that bill, and particularly Section 4 of that bill, exposed the office to substantial risk of being challenged in the law courts. So we have always known that. In fact, I say that it's even a credit to the Committee on Constitutional, Legal, and Parliamentary Affairs to have worked on a bill that has survived 8 years or 9 years in existence. Because at the time that we were working on the bill, many people, including the former Dean of the Faculty of Law, Professor Raymond Atuga, indicated that the bill would not survive scrutiny in the Supreme Court. So we have always known that the bill was exposed to substantial risk of being struck down as unconstitutional.
So what you have always known is what may happen now. But in this particular case, one last question, then we conclude this. And it was a question I asked when I was introducing the fact that we'll be speaking to you. The president, when we started this debate about the constitutionality of the OSP's office and people asking that the office should be scrapped, was clear in his mind about what he preferred. His preference is that, yes, the issues are germane, but let's allow the office to continue to exist. That is the president's position. The Attorney General seems to have taken a different position when this matter comes in. Was the Attorney General obliged to, take a position that emphasizes the position of the president? Or should they have gone for that principled position that they've always held all this while? Which one should they have taken?
So let's try to reconcile it. The Attorney General is the principal legal officer of the state. The Attorney General is mandated to defend the Constitution, no matter his personal idiosyncratic views. That is the Attorney General's office. And if in defending the Constitution, the Attorney General's professional view is that there is something fundamentally wrong with Section 4.2 of the Special Prosecutors Act as against the Constitution, nothing prevents the Attorney General from saying so. In fact, it will be the height of hypocrisy not to say so. And it will challenge his professional competence not to say so. That doesn't mean that the Attorney General doesn't subscribe to the position of the President. That doesn't mean that. It just simply means that the Attorney General is being professional and legally astute in defending the Constitution. Now, I have no qualms with that. And the fact that Attorney General has said that does not mean that the court will go along with him. Because in the tools of interpretation, the Supreme Court can adopt a purposive approach to the interpretation of Article 88, 3 and 4. So it's not simply going to be a literalist approach. The Supreme Court can decide that it will adopt another approach. In fact, And the Supreme Court has done that in the previous action of Ken Kranchi against the Attorney General. Okay? So the president's position that let's leave the special prosecutor to do his work. I share in that absolutely 100%. I believe that we should leave the special prosecutor to do his work because of the mischief that we intended to cure in the establishment of that office. That if we scrap the office, what is going to replace it? Because the Attorney General the office has been in existence since the creation of the Republic of Ghana. And even before the creation, that office was an extension of the British Empire. And we had the Solicitor General in this country. So corruption we've come to accept cannot be fought by an Attorney General who is a Minister of State, who sits in cabinet with collect ministers, who owes a duty of care to political appointees of his government, and so is unable to exercise the independence required to deal with corruption and corruption-related offenses. In fact, Dr. Ayini in Parliament had also raised the issue of even corruption-related offenses. What are they? A new genre of corruption or offenses that at the time that the bill was introduced in Parliament was not clearly defined. And so I simply say, without any fear of equivocation, that the office of the special prosecutor was set up to tackle specific offenses that, in our view, were not being adequately tackled by the existing institutions, be it IOCO, be it FIC, be it the Attorney General's office, be it the police. The offense of corruption, corruption-related, and breaches of the Procurement Act were not adequately tackled by these institutions. That was why the Office of the Special Prosecutor was created. So that was the mischief that we intended to cure. If we remove the Office of the Special Prosecutor, if we scrap the Office of the Special Prosecutor, we go back to the status quo ante. Is that what we want? If we remove Section 4.2 from or if the Supreme Court strikes down Section 4.2 of the Special Prosecutor Act and Section 4.1 of Act 959, the Special Prosecutors Act, we'll still have the Office of the Special Prosecutor, but that office will operate at the pleasure of the Attorney General. Is that what we want? Do we want an office that is independent of the Attorney General, or want an office that will be controlled by the Attorney General? We have seen what Fiat does. We have seen what Gazette notification has done in the chieftaincy institution until it was removed by the Constitution. Because where the discretion to give a fiat is vested in an authority, that authority can decide to give that fiat or not to give that fiat. And in the case of fighting corruption, that can be disastrous for this country. Is that what we want? So we leave it to the Supreme Court to assess the sentiments of the people of this country and the Constitution, what the preamble of the Constitution said: we, the people, in exercise of our sovereign right, to establish a form of government for ourselves, against what Parliament did as representatives of the people, to exercise its sovereignty to create an institution that statutorily transferred some discretionary power of the Attorney General to the Office of the Special Prosecutor. Whether Parliament could do that and was right in doing that, this is a matter that is very legal. And so, even though I want the existence of the Office of the Special Prosecutor, and I agree entirely with the President that we should leave that office to do its work. I'm also not blind to the fact that the Constitution is supreme. And so, if an act of Parliament is inconsistent with the Constitution, that act, and that is Section 2 of the Constitution, that act ought to be struck down. We wait to see what the Supreme Court will say.
Alhaji, thank you. Thank you for speaking to us this morning.
You're welcome. Thank you.
That's Alhaji Inusa Fuseini, who is former member of Parliament for Tamale Central. I was there when all the work on that particular act was done. So he speaks out of institutional memory, his own reckoning of what happened and how they end up with this particular act, which, like he said, the warning has always been that will come to this day. And he reminds us of the fact that the Attorney General has a work to do, to uphold the Constitution at all times. So the argument in itself is not a problem. He said the problem might perhaps be the fact that he can trace lawyer Damte to his relationship with the Deputy Attorney General, Justice Remsai, who is actually the one who seems to be the one who will be arguing in this case.